I'm Cody Caplin. I'm from the First Nation. Back in 2018, me and my brother were charged for illegal fishing. We've been in the court case. We've been in the system now for 4 years battling. So he's still battling, but in the end, my lawyer told me in my best interest would be to take a plea deal. I was uneducated. I had no knowledge in what I know now. So I took that plea deal, and now I'm looking at very hefty fines and a lot of lawyer fees, and so yeah, that's where I stand right now.
Hi, I'm Cody Caplin. I'm from the First Nation. The challenges that I'm up against today are against DFO and the RCMP. So my fishing case, I'm getting charged with 10 charges. I'm looking at roughly $40,000 in fines and $30,000 roughly with lawyers right now. So I'm up to about $70,000 in fines and lawyer fees.
As of now.
Yeah. And so I'm still in court, I'm still fighting. And have a case management on in November sometime. That's when we're going to let them know that our expert witness is going to be Chief Dell and whoever else. I think we have a historian and a couple others.
My father wasn't really a big fisherman, but they built a lot of carpentry, and they always work for their family. They always work for their money, but hunting. They always hunted and gathered and medicines and. Like us, we only started fishing maybe 6-7 years ago, when we really only come back to our community when we were about 14-15 years old, and then that's when we start getting more involved with our culture, like medicine gathering and hunting. Well, we always hunted, but then the fishing part. So we started fishing about 6-7 years ago, fishing salmon and fishing lobster, and
we always been harassed ever since.
We've been harassed, yeah, but we were later, we were introduced, we never knew what our treaty rights were and the Constitution and all this. So once we were educated on that a little bit more, that's when we started exercising it. But when we started exercising it, that's when we became the problem. That's when we were the bad guys to DFO and to the government, and they were always harassing us and stealing our gear and
racist comments.
So when it came to fishing, in the end, they would take our traps every day. We would put our traps in. They would come up with a boatload. DFO. We would put more in, they would take our traps again. Anyways, yeah, so we were charged with illegal fishing. Every day we have to turn our shoulder,
They were profiling you.
Yeah.
That's what they were doing.
Yeah, exactly. They actually profiled us in court.
Yep.
Yeah.
It's all documented. They said that we were basically we're dangerous to society because they were trying to paint a picture like we were going to hurt them while we went there to retrieve our boat and stuff, right?
Yeah.
So they were talking. He had his gun out. And
they had to press the emergency
They were
button.
trying to paint a picture that we were boxers. We used to box, when we were kids. We were 13 years old. We're 35 years old now.
Yeah.
You know what I mean? He was trying to make us look like criminals.
Yeah, so we went there because they stole our boat on us.
Sounds like they're trying.
We never did anything wrong. We were out there trying to provide for our families, provide for ourselves and our families, and so we come in, they steal our boat. If someone steals something from you, what are you going to do? You're going to go back and try to retrieve it. Well, we went back trying to retrieve it, but they're like, whoa. And they were trying to make us look like we're the biggest criminals in the world. We want our boat back.
We wanted to know more.
We want to know what's going on here. So when it came to court, that's when they really made us look like we're the bad guys. You guys are.
And they called us the Caplins.
Yeah.
Right away they profiled us, the Caplins. They're bad. They're in the community.
Yeah.
They
try to brand you as terrorists from the sound of it.
Basically,
That's what they're trying to do. Yeah.
They're trying to paint a picture something I'm not, you know?
But all of this wouldn't happen if our band council wouldn't sign that FSC agreement.
Here's the problem with that agreement, that fishing agreement. It's irrelevant because you've got two federal agencies agreeing.
That's what it is.
It's useless. The only thing that counts is your treaty because it was made before, and it doesn't restrict you on anything.
But by them
And then-
signing that agreement, that crunches our treaties. You know.
No, it doesn't.
But
It can't.
I know, but it that's what they're doing.
That's
they're trying to do.
They're going to try to argue that.
Yes.
But you've got to actually get into a process that changes the treaty. They can't change it with that agreement
No, I know.
because it applies to too many people. That's what you need a lawyer to argue. Hey, the treaty is valid. It can't be changed. This can't change.
Protected under Constitution.
Yeah.
25 and 35.
That agreement, the only thing it could do would be to comply with the treaty, and it can't take away little bits and pieces of it so that so that they can charge you.
No.
The treaty still
Stands.
is superior.
Yeah.
Section 35, it's superior yet. No matter what they've done in that agreement.
Yeah, no matter what agreement they sign.
Treaty,
How do you
yeah,
frame it?
that's your best one. Yep.
Just which treaty in particular, or just the?
Well, your
yeah.
1752, your
Just
friendship one.
If I can make a
That's-
correction, if I can. make
Oddly
a correc-
enough, to me, that's the most powerful treaty you could have any place in Canada, because it doesn't get into details about anything else except
And that treaty is protected under Section 25 and 35 of the Constitution, so
Yeah.
they cannot override that. It's
no.
Well, keep in mind that the fishing, the logging, hunting, and gathering are all under the same treaties.
It's all in there,
It's all
Under-
and there's no other restrictions
so
on
you
it.
could refer to the treaties of 17, 25, 26, 52, 60, 61. They could be introduced. And then after that, if the judge says maybe this treaty over here doesn't apply, well, there's other treaties that would, but they all do apply. And when I went to court, I fought my logging case on the treaties of 1760, 61. And one of the things they asked me to do was show a direct lineage to the natives who signed the treaties. Well, they didn't know I could do that.
We could probably do that for me too, eh?
Now, please let me finish. I didn't think of it at the time, but should they ask you to show a direct lineage to the natives who signed the treaties, ask the Crown. And that would include the judge, the prosecutors, and everybody else in that court that works in the court system, to show a direct lineage to the people who signed.
Treaties.
On behalf
No,
of
no,
the British.
that signed the that's signed onto the Constitution, okay, to show that they're Canadians, and to say we don't want the ones that's married in, adopted, or somehow came under this umbrella. We want to see a direct lineage. Because if you want us to show a direct lineage to the natives who signed the treaties, we want to see you to show us a direct lineage to the natives, to the white people who signed onto the Constitution. And I don't think they're going to be asking you to, at that point, if they go that route, I think they're ready to drop it. Because, if what they want from us, ask the same thing for them in their system. Show a direct, because that's what they asked me, show a direct lineage. And they didn't know that my mother and my Uncle John were from Big Cove, which is today El Sabuktu.
Yeah.
It is the Rishibuktu Indians. It was the Rishibuktu Indians who went down and signed the treaties in Halifax in 1760-61. And I was able to show a direct lineage. Well, they dropped it like a hot potato. And they moved on, and eventually they just put a stay of proceedings on.
Hector,
Yep,
you said we could do that for me, right?
yeah.
With grandmother.
Okay.
Marion?
If it's okay with you, I'd like to tell you exactly what the root of the problems are. And You are right in the things that you're saying, but the problem lies within. First, I would like you to say that when you go to court, you're picking up where the Supreme Court judges and what they said on the 17th of September, 1999. Donald Marshall Jr. is a Micmac. He has a treaty. He has a treaty right to fish, treaty right to sell, and there's no such thing as a closed season, or closed time as they call it.
Or
And-
restriction on that, on sizes.
And
that's,
He went in there as,
well,
as an individual right. That
They
wasn't
actually
it.
discriminated
Well,
against us.
I'm just
when
two quick
they told
minutes
us we
away
could only
from
take a
your-
certain size because the year before the commercial fishermen had a bigger size gauge.
Oh, yeah.
Okay, and then when that court case was made public, John Chrétien put an interim fishing agreement on the table with $159 million attached to it.
FSC.
With no, you're a little bit ahead of me, but you got the right idea though. So that's what happened. The Indian Act chiefs in the Atlantic region did not support the writing in of treaty and Aboriginal rights, and I have those informations that I would make available to you is exactly what you need. Now I'm going to go to say the first persons to sign the first interim fishing agreement was the Union of the Brunswick Indians, where Everett Martin, chief of Eelver Bar, was a board of director. There was 15 of them that was represented by Arthur Baird, who was the Indian Act chief from St. Mary's. As the fisheries, the head guy for fisheries, he didn't call himself Indian or Maliseet. He said, I'm the commissioner of fisheries for 15 Indian reserves. That's already an assimilated term. He was the first to sign in Moncton at the Assumption Place in Moncton at that hotel where he met with DFO, committing us to undoing the treaty right, which wasn't theirs to begin with. John Paul, the Atlantic Policy Congress, was the second to sign on the 6th of December 1999. Arthur Baird signed, I think it was on the 2nd of November 1999, just in short weeks after Marshall was made public. So therein lies your problem. You have a good connection in the way that your grandmother Marion is my mother's sister. Your grandmother Marion is connected to Hereditary Chief Nick. Joe Simonson's mother is the daughter of Nick's grandfather. That's how close we are to being hereditary. But the problem that you encounter is with the chief and council system. Everett Martin, who was chief for us, excuse me please, Everett Martin, who was the chief of us, the Indian Act chief, when he got involved with the Union of the Brunswick Indians, he gave up his title of the Indian Act chief to become a board director to a corporation, a provincial incorporated one at that. So, and I'll tell you what they did. I'm going to be quick here because he's got his camera on. There was a band council resolution put on the table, and I want you to know, and I'll be willing to say this too in your defense under oath, I'll be your witness, that in November, I think it was on the 8th of November, 1988, Prime Minister Brian Mulroney undone a land council resolution using the Instruments Act. That means in 1999, when the Marshall was made public, the band council resolutions were cancelled out 12 years before that. And that's what they used to undo your treaty right. That's what they did and used to undo a Supreme Court ruling. And I just so happen to know where to find that. In fact, I have an agreement that was signed by their lawyer, Bruce Wildsmith, professor of law at the University of Halifax Law School. He, in his first paragraph of that letter, dated in year 2000, March 2000, he said, I fear that the financial incentive that's being offered by the Government of Canada will be enough to encourage these chiefs to sign an interim fishing agreement, totally disregarding the treaty. I have that. That's exactly what you need as your witness.
That's why the treaty is still supreme.
That's right, you're right.
They ignored it. And
But I'm saying, like, you know, you guys are really, really quite innocent, and I admire your determination. And not only that, you have a few bucks to work with. Us, we don't. But we have the information that you need. And but you need to be more a little bit more aggressive in your ways. I told you at the end of July you need to fire that lawyer. You need to make file a motion in this court saying you want this case transferred to a federal court. That would have made you start all over again. And maybe it's not too late.
Oh no, we're doing that.
Well, okay, it's going to happen automatically anyway. Soon as the information on Section 35 and the constitutional stuff comes out, automatically the
federal.
province is thrown out.
But Mr. Del Rally, please, they don't recognize that at all. That's not even an agenda item. That's not even of any concern. That's not it. They're violated the Department of Oceans and Fisheries laws. That's what they're being charged with.
Oh yeah, okay, but you've got your constitutional arguments which supersede that.
Yeah.
Those violations.
But they're not using them, Del. They're not. We want them to.
But we will use them.
His uncle, who was a band counselor for about 30 years, he is the guy who called me and asked me if I would help his nephews. I said, yes, of course I will. He actually drove from the court, come to pick me up, and drove me up to the court, and he brought me there. It was at his request. Like, these guys, I know them, I see them every day, but I don't really know them, you know? But I know him well, and he's a good friend of mine. In fact, his grandmother and my mother are sisters. So we go have coffee pretty much on a regular basis, you know? So I would be willing to help these guys, and I think Del Riley and our hereditary chief know my credibility. We are not paid to come here, but thanks to you guys, we're here. And we gave these people the best information that they had, and they accepted woefully. Mm-hmm. We saw Tom last night change the world, the course of how things are done with us. Our rights are formally recognized and put on paper last night, and you guys supported that. He was one of the first guys to speak. Yes, I agree with that. Mm-hmm. And that's exactly what we needed. We laid the foundation, thanks to Del Riley, that no one has ever done before. We made history last night. So we're here for you, and we have one of the most credible men in this country, and we have a guy that probably has a fairly good academic background. He's with us. Mm-hmm. As I said to you, and I'll say it again, we have a scientist with credibility that we have never had before. When I spoke to her recently, I placed Nick before her. I said, you're the most important person I ever met on earth, the most important person that come into our lives. Well, with the exception of Nick, you know. So these are, now we're talking seriously. Now let me just show you before I stop talking. Here's John Kirchhoff undoing what's written in this country's book of constitutional laws without going through a constitutional conference in the back room. He went in his second term of Prime Minister campaign in Verdun, Quebec. He said, you vote for me, I'm going to give you the legal veto power over what you don't agree with in the Constitution of Canada. And that's our treaty on Aboriginal rights. He came to the Atlantic region, he met with 4 premiers, 3 of them agreed with him. If you look at the population of 4 Atlantic provinces, you wouldn't get 2 million people. In this Supreme Court of Canada ruling, it said it must have 50% of the population of Canada in order for it to be valid. Mm. So we have a whole lot of things. And I'm going to show you one more thing right here. This is what they did right here. He said, we're going to give legal capacity to the Band Council to undo our treaty rights. I'm going to show you that, and I'm going to read it out to you in 30 seconds, please. This is Bill C7, and I went to Ottawa, and I joined with 300 Micmac Aboriginal women who came in from Vancouver to protest this. I met with them in Ottawa. They were at the Marriott Hotel, where AFN was there, and this is what the women asked me if I would do. Are you going to come with us? Where are you going? We're bringing our protest into Parliament. I said, yes, I came here for that. Now, this is what they did in Parliament in legal capacity to the Band Council. This is Bill C7. Powers, lawmaking powers, powers of the band council. In section 15.2, actually 15.1, it says, to acquire and hold and dispose of rights. That's what's happening to you guys.
Yeah.
That's why we're here now.
Dispose of rights.
Yes, it says in 15.1b, it says, acquire, hold, and dispose of rights. That's Bill C7. So, in the Parliamentary Standing Committee in Ottawa, I went in with 35 Aboriginal women. And I said to the women, how are you going to get in? She said, you follow us, we'll show you how we're going to get in. And those brave women, I told them, I said, I came here to support you. Yes, I'll go with you. And we all went into Parliament. We're in a Parliamentary Standing Committee, and there's this one Aboriginal woman from Winnipeg area, taking pictures. And the chairman says, ma'am, no pictures, no videos. We're going to have you removed. She said, yes, you can have us removed, but we're all going to sit on the floor, and it'll be midnight, and you still wouldn't have us all out. Oh, no, ma'am, no, there's no need of that. Then they took a break, and the women huddled like you would see in a Super Bowl football game, all them players bending down talking, you know? When they got up, I walked over to the women. I said, did you come here to kill Bill C7? She said, yes. I said, well, you're not going to kill it with emotions. Well, do you know how? I said, yes, I do. How would you know about that then? I said, well, look, this is me. I sat at a constitutional conference table. Well, would you write it out for us? They gave me an open face pad and a pen. I went and sat in a corner, and within 15 minutes I wrote 4.5 pages for them. They gave it to the parliamentary committee, and that was the end of John Critch's Bill C7.
Oh wow.
Yeah, we can do it. The most credible man right here. We have our hereditary, and I'm here for you too.
Dale brought up an issue of sovereignty. We have to stick with our sovereignty. And I agree with you, and I had that here. And look at it, the justice in acquisition. Okay? Natives in owning of this land is legitimate and rule following. Natives owning this land is in keeping with the rules of justice. There never was a legal transfer of Mi'kmaq to the Crown. Crown claiming of native land is not justice preserving. Okay? Justice holding. Let's look at 4 points here. Justice acquisition equals, an unjust acquisition equals an unjust holding. So they got this country illegally, so they don't have legal holding to it. That happened. Unjust acquisition plus a just transfer equals an unjust holding. That has happened. Unjust acquisition plus unjust holding equals an unjust holding. That has happened. Just acquisition plus a just transfer equals just holding. That has never happened. And at that point, you ask them to show you a title to this land that meets this criteria, and they're not going to be able to do it.
You guys are coming to court with me.
Right?
Well, you know, let me tell you another thing too, is that when I sat in your court, your uncle asked me to sit in and listen because he knows that I know this stuff well. I had coffee with him a few times and we talk about things like that. Okay, so what has to happen is that you must, and of course you didn't know, but you're going to know now through us. What has happened is that a Supreme Court ruling was brought to these Indian Act chiefs in the Atlantic region. Not one of them sat at that table. Not one was willing to support it. And you've inherited that. You don't know because you're innocent to all that. But I know. So what they did was that they put an interim fishing agreement on the table. They used a band council resolution, which was dead since 1988, November the 8th, in fact. And it was undone by way of the Instruments Act that was applied to it by Prime Minister Brian Mulroney and that cabinet. And the Parliament as well. So you guys didn't know that, but we do. So now what I'm going to say to you, you must say that I want these band council resolutions. I want these interim fishing agreements put on the table here in court, in this court of law. Who has the authority? Who has the power to undo my treaty rights? Because I'm going to tell you what their Supreme Court said. Now I'm going to give you just a little bit of information since it's being recorded. Pierre Trudeau said, "I'm the Prime Minister. I can undo this British North America when I please. There's not a damn thing you can do about it, provinces." And he said the same thing to the National Indian Brotherhood. So, these English premiers, most of them conservatives at that time, on the 18th of April 1981, they brought Pierre Trudeau to the Supreme Court of Canada. On the 28th of September 1981, Chief Justice Burl Laskin made their findings public. When he read that to the media, he said, "The only criteria for changing constitutional laws in this country, which is our Treaty on Aboriginal Rights, is that when the Prime Minister calls a constitutional conference, invites the premiers, Aboriginal peoples, the media, it must be done in an open forum, and when a decision has been arrived at, it has to be voted on by 7 provinces that make up 50% of the population." And that's not what's happening now. Immediately, Jean Chrétien, who was then Prime Minister, put the interim fishing agreements on the table. And I have some of the best for you. And I'm going to tell you why I'm saying it this way. We'll use the one from Burn Church. Because unlike the one at Ilver Bar, McKinsey, who was representing DFO, James Alexander McKinsey, representing DFO, he was at Ilver Bar. But let me tell you what's different about Burn Church. It was the Deputy Minister of Fisheries and Oceans. At Burn Church, where they allowed, what do you call that there? Offered the Burn Church Band Council a $30,000 signing bonus. And all you had to do was sign, and you could have got up from that table and went to town and bought yourself a new car, which you couldn't have done an hour before that. So I want you to say this, it's not a secret anymore because it's being recorded. I know where to find these things, and these things will be available to you, but you guys got to help us. I mean, you did a big thing by bringing us here, went out of your way big time, both of you. You left the Trans-Canada Highway, we went in to get Nick. That's a good thing, thank you. And you did the right thing. But you guys got to continue to help us. We have the information though. Mm-hmm. So, and all this stuff is available to you. So I just want to stop by saying one more little thing to you. See, this is me right here, joining the women. 300 women came in right here in Ottawa. This is us going into Parliament. That's how we had to get in. The women got us in. Yeah. So here's their laws that you can use against them. This is what they're saying that you can use. It's on page 72, section 52(1). It says, "The Constitution of Canada is the supreme laws of Canada, and any law that's inconsistent with its provision of the Constitution is now void and no effect." You can use that to kill DFO's charges against you. This is their supreme law. So you interpret supreme, I mean, even though you may not know, but now you will. And I would like you to believe me. I would like you to use what I'm going to tell you now. You can say, "I interpret supreme to me God. God is supreme." And you know what they're going to tell you? "Oh, Mr. Caplin, we're living in a secular society. We don't use that. You can't use that. It's inadmissible." Okay, then you can say, "Well, why? Here's your book of constitutional laws. I'm going to look at not page 1, but I'm going to go to page 3. And you know what it says there? Canada is founded on the principles that recognizes the supremacy of God and the rule of law." Are you secular? You don't know your own book of constitutional laws and you're going to be passing judgment on me? You got him there. I did it before. I'd like to share another critically and vitally important pieces of information with you. Although I didn't know this fellow, he identified himself as Métis, living in the Carrick, New Brunswick area. I don't know how he found out about me, but he called me up and he said, "I got caught for fishing by DFO. I heard you're well informed." I said, "Yes." "Would you help me?" I said, "Yes." So what he read out in court, I'm going to make available to you. It's already on court transcripts, where it cancels out this country's Book of Constitutional Laws, which is the British North America Act. When he read that out in court, this was done on, I'm using the term, and I'll put it in quotation marks, Prime Minister Mackenzie King, 1946. He authorized a man by the name of Maurice Oliver to write letters patent. And when you read that, you're going to see the nice little word in there, spurious. And that word literally means not what it purports to be, which means it's not real. So Maurice Oliver wrote, and he was the president of the parliament or something like that, pretty distinguished person with a PhD degree in the 1940s, which is quite remarkable. He wrote the letters patent. Mackenzie King took them and signed them without bringing them into Parliament to be debated. There's a process there. Del Riley knows that probably better than I ever will. Anyhow, there was a process there. That didn't happen. He didn't bring it to the attention of the premiers of provinces to bring it into their legislatures to be debated. And he passed it into law effective on October the 1st, 1947. And it reads at the bottom, the only thing that this new Governor General can do when he reads that he's holding office by way of grossly illegal and unconstitutional letters patent. When this man, Stefan Richardson, read it out in court as his defense in Caracat, the judge was sitting there. It was a woman judge named Landry. There was a woman prosecutor, kind of tall, thin woman. And the court just froze. If a mosquito had flown across the courtroom, it would have sounded like a supersonic jet flying over. That's how much noise it would have made. That's how silent it was in that court. And when that judge, a Landry woman, could compose herself, her mouth was moving, her lips were moving, and no words were coming out. And I was at that man's house till 11:45 that night telling him, okay, she's going to say this, you're going to do that. So will you have an answer quick? And that's exactly what happened the next day. Where did you get that? He said, from your Book of Constitutional Laws, Your Honor. It shut her up big time. So it's already on record, and we'll build on that. Thank you.
I love that idea.
This is Jim Kritchak. This is taken from the Globe and Mail a few years ago. In fact, the woman that photocopied it for me, she cut the date off. But it looks like in February 2017 in the Globe and Mail. On February the 2nd, 1996, the act is short, just 232 words, packed in consequences. In the glow of a near victory by separatists in 1995 referendum, Prime Minister John Chrétien proposed and Parliament passed an act of respecting constitutional amendments. Parliament does not have the authority to do that. Does not. As the Supreme Court said, it requires 7 provinces that make up 50% of the population of Canada. That's the only criteria, and we got to be involved. Men with his credibility has to be involved, and that never happened. The British North America Act, okay. John Chrétien proposed that Parliament passed an act respecting constitutional amendments. The British Columbia, Quebec, and Ontario gained a veto over constitutional changes. Atlantic provinces representing a majority of their people could team up for a veto. That means anything and everything that you're talking about could be vetoed. They have a veto power over it. And Saskatchewan and Manitoba were at the mercy of more populous Alberta and the Prairie veto. So Alberta was given a veto. Few were happy with the result. The dissolutionary package of constitutional leftovers, described by one Globe and Mail columnist, was layered on the Constitution, which required 7 provinces representing 50% of the population for most changes. Constitutional reform was already difficult. The new math made it nearly impossible. No politician has dared test either formula with a constitutional amendment in 1983. And they're wrong about 1983. It wasn't 1983. It was on the 17th of April, 1982. We sat at a constitutional conference on the 15th, 16th of March, 1983 at 9 a.m. So what you got to do, and I mentioned to him once in passing, I said, you got to take on the government of Canada. And he said, we don't have the money to do that. And I believed him. But still, you have the credible evidence, you have the credible witnesses that are here. I'm sure Bill Riley, well, not only I'm sure, I'm positively sure he's here because of you. Nick is here. All I had to do is tell Nick, give him a good introduction. He's here. You don't have to twist my arm. I'm here. Because I admire you guys for, doing what you're doing, because no one else has ever done that. So, as you saw last night, consider that, I don't know how to say it in a good choice of words, but let's say literally that was a blessing in disguise for you, what took place last night over here. These people that were sitting there, they're just as serious about this as you are. That woman that was sitting over there, Michelle, I've known her for an easy 15 years, a little bit more. These women are serious and they're with you.
Yeah, I gathered that.
When she came over and saw Nick, she was almost in tears. Nick, I never thought I was ever going to see you again. Actually, you almost didn't. Open heart surgery,
Yeah.
So you have new life. Fire your lawyer like I told you in the summertime. You don't have to do it in a mean way. Stand up in court. Your Honor, I have lost confidence in my lawyer. Yes, Mr. Caplin, why? Well, he said this was an unwinnable case, which he had made. It was in collusion with lawyers from Birchill's law firm in Halifax. He said this is an unwinnable case and don't waste your time. And that's when he came here, and we're paying him $10,000, $15,000, $20,000. So tell him that's enough criteria for me to want to fire him without prejudice. Thank you.
Like, I'm gonna fire my lawyer. Let's say I fire my lawyer. Hector I could hire Hector
As your Putus.
to
You
speak
don't have
for
to
me.
replace, or say you've got another lawyer. You've got representation,
Okay.
and
So that's all
you
okay.
just say his name. That's all you say.
Okay.
And we'll do it for you.
Okay.
We'll do it for you. Because you see, you guys are well intended, but you're not as well as informed as you could be or should be. We are.
That's why we're here, though.
That's right, yeah. So but this is what's going to happen to you, and you need to bear witness to this. You're not going to be popular with the band office.
Oh, I'm already not popular. I'm fine with that.
They already hate us.
No, I'm ready to fight on every front.
A few choice F words.
They're-
They're next.
So,
Yeah, they're next.
let me be the first to say welcome to the club.
But you know what? The only little trouble that you're going to have is making up your minds on is this. I do have the Overbar Band Council, interim fishing agreement, okay? And although the figure is not written there, it's my clear understanding that it was $11 million.
I have 5 years of it, of the agreements.
Yeah, but those are all after, that's true, they're valid, but those are, the first ones you need is the ones that were signed in the year 2000, 2001. Those are the ones that canceled out everything.
And how do we go about fighting that?
I have them.
No,
You
but
can
how
use-
do we fight them on that?
Our
Well,
treaty and constitution.
You could say what I just told you about the Supreme Court ruling. You could say your Supreme Court said this is the only criteria for changing constitutional laws in this country. And I'm going to show you what it says in this paper right here. This is what I took from their book quite a few years ago, so when I meet up with people like you would know. Now, this is what it says on page 72, section 52(3). The government of Canada and the provincial governments are committed. No, I'm in the wrong place. Okay. Section 52(3). Amendments to the Constitution of Canada shall be made only in accordance with the authority contained in the Constitution of Canada. What they did is all in back room. The government of Canada represented by James Alexander Mackenzie, who was a lawyer from Glace Bay, Nova Scotia, and he was drunk most of the time. I used to get him real mad. I would sit in the meeting. I said,
So we can challenge that. Can we challenge that? Can we like overturn the interim fishing agreement? Right?
Absolutely. But you guys got to continue to be as brave as you have been. So Nick will commit himself to you. I'm pretty sure of that, and I've already said that I would.
And just a word of caution. I think you better be on alert for monetary
Losses.
that they may want to offer you to sign off on that.
I ain't signing shit.
So just be open. That's a possibility.
Yeah.
Okay, so
No, I know what they're like. The Van they're corrupt. Like a majority of them, anyway. Not everyone.
They all are.
Yeah, but they don't know though.
They don't
Some
know.
of them don't know. They're innocent, right? Like you said. Some of them feel like they're there for the right reasons.
Well, they're loyal to Everett Martin. Let me tell you what Ben Councillor Candace told me. I said, Candace, you're a councillor now. See that river where you live? That's our river, and it was signed over to the province. I would like you to make an effort to get it back to us. And she said, no, I will not go against Everett Martin, anything that he said. And did. I said, that river didn't belong to Everett Martin. It belonged to us, and now you're a councillor. I want you to get that river back to us. And she said, no. But let me tell you how far we can go, and I say this among very good friends. And I'm not saying I'm going to use the word confidential, but it's being recorded, so that's okay too. When the tough gets really going, really tough, this is what we can do, and I've done it already. And they were angry at me, but I'm going to tell you anyway. I'm hounded by the cops, the RCMP. They stopped me right after the exit, getting on from Middle Bar going to Campbellton. Within a mile from that ramp getting on, they stopped me. There was 5 RCMP cars there. I got beat up really bad.
You got beat up?
Yes, really bad. They put me down on the road, and there was a black guy. He had my arm so high with the intent of breaking it, and one guy was RCMP leaning with his elbow on the trunk of the car and pounding my head with his knee. So, anyway, I was in court. I was in court for 2 years and 10 months. When it looked like they were going to beat me, and I knew exactly what they were going to do. So, 10 months, 2 years and 10 months later, coming down to the last minutes, the RCMP got up and he said, Your Honor, those papers that Mr. Pictou is using in the court of law are inadmissible. And the Crown Prosecutor got up and agreed with him. Your Honor, those papers Mr. Pictou is using in the court of law is inadmissible. They're photocopies. So I said to the judge, Your Honor, could I call that RCMP back on the stand? Oh, yes, Mr. Pictou, this is an adversarial system of justice that we have in Canada. Yes, of course you can call him up. RCMP on the stand. RCMP goes up there, and he takes the Bible. You swear to tell the truth, the whole truth, nothing but the truth. Help me God. Yes, I do, Your Honor. Sat down on the bench, and I asked him, I used the word sir. I said, Sir, are you Christian? He said, Yes, I'm a Catholic. I said, that book that you took an oath on, would that be the Bible? Yes, Mr. Pictou, yes it is. I said, well, could you tell me then, is that the book that Jesus Christ wrote? Oh, he got mad at me. The judge stood up, he groaned at me, grinding his teeth like a mad pit bull, you know. Mr. Pictou, he says, where are you going with this? And the Crown Prosecutor, inadmissible. And then he started talking, he said, blasphemy. And finally, the judge, he's beginning to sit down. He was up there for about a minute. I said, it's a fair question, Your Honor. If that's the book that Jesus Christ wrote, then my papers are no good. And that was the end of their court. We can use their God against them. I've done it already. But you got to be brave to do that, because a bucket of crap is going to fall on your head. But we did it. So that place in Caracat where we used their constitutional book of laws against them already, But this guy went off the rails. And when he made another court appearance, this is what he said. He's trying to convince me that he was right. That judge is in a conflict of interest. And I told him that's not good terminology to use in court. We're talking about constitutional laws and treaty rights. That word, conflict of interest, is a slash word that has no meaning at all. And I haven't been involved with them since. So now you and I and our good friends here, we're willing to help you. And that's how we're going to do it. If you say yes to that, I'm in agreement in helping you.
Yes.
Thank you. Now, I like to get these guys to say, while the camera's still on, that they agree to use the Band Council resolutions, the interim fishing agreements, and the persons who signed them. Because that's heavy, heavy stuff. Because these guys can lose everything they have right now. Everything.
I
Well,
thought,
you gotta debunk that agreement, but that'll be easy because
Yeah.
your treaty automatically does it.
That's right.
like band council resolutions, aren't those all illegal?
No,
documents?
they're not legal documents.
No, they're all illegal documents.
It used to be, if it's okay with you, please. It used to be that the Band Council resolutions had even more authority, more power than federal laws. Certainly provincial. So when Brian Mulroney did what he did in 1988, on November the 8th, was to cancel the notes, and they are even worth the papers written on. It might have been before, it is not now. And it hasn't
Well,
been.
no, your big problem is the minister's the boss, and that resolution involves a minister of Indian Affairs. So
Yeah,
you
because they
can't,
answer to him, Mark Miller.
Because
Right?
he can disallow any
Yeah.
resolution there. Because he's the boss of chief and counselor. He's underlings. He's servants. And this is the other problem that they have in making that agreement is you've got two federal agencies making an agreement for First Nation rights. That's wrong.
And
Our rights are already made.
It can only be done by your original treaty people, the
Exactly.
the elders, the ones that originally made the treaty,
Yeah.
or all the people together, all of the people. That's where the authority for your nation still lies. So,
Del
and that's the only way you can change it.
Del Raleigh, I'd like to share with you.
But they're going to try to bury you in in their rigmarole there.
Oh, yeah.
But back to the fishing thing, I think you should be awfully encouraged what you heard last night.
I am
Very, very,
very happy about what I'm hearing.
Yeah.
Very
So-
encouraged. I'm inspired by you guys.
And I want you to say,
brings a lot of hope. Brings a lot of hope.
twist your arms a little bit. I would like, before the video shuts off, that you give a nice thank you to Del Riley. Nice thank you to.
Oh, I think it's all is. You guys are what we need to bring all our rights and everything back to our people. Get rid of all these
And I want
the
you to
Indian Act.
understand, when we said bring our rights back to our people, this isn't just about me or Del or you guys or Hector.
I mean,
It's
for a
about
while,
our
everybody.
This is, it's not something that you're doing that's, what's the word I'm looking for? That's selfish, for me only.
Not just individually.
You're looking at it across the
Broader-
board.
Actually, I'm
broader
not looking at it
spectrum,
as a
no,
financial
which is
gain.
great.
I'm looking at it, I want to hold them accountable.
Yeah, and in our tradition, natives were considered great, especially the leaders, by acquiring as much as they could, not to hoard it, but to give it away to those who don't have it. And that's what you're doing today. You're getting as much rights recognized and in place and enforced, so others can benefit from it. And I think you guys should. It's an honor for me to sit here with you guys.
It's an honor for me as well.
You guys are brave and admire you.
But it's a fight, and it's
It is, but it's a fight we're willing to do.
yeah, but it's it's heart wrenching, gut wrenching at times. So
Oh yeah.
It's a lot. It brings a lot of emotion.
So
It's a lot of emotion too, and a lot of.
let's.
My prediction is you'll win. Okay, but again, you've got a long process yet. So
Yeah.
One of the things that you need to give some serious consideration to is the first thing they're going to do is take away from you what you have now. If you have a license for cannabis, that's going to be gone. For your
We
fishing,
operate on
We
our sovereign.
operate under sovereignty, so.
that could be gone. Well, just some fun things to think about, okay? And that's how they function,
They will not take
They won't buy
They will
us.
not take it away from us though. They tried,
okay?
and we reopened 2 days later, and they never touched us.
We
Since.
try to discourage us,
So
but
coming here, based on what Tom put on the table last night, maybe that's some protection for you. I'd like to believe it is. So anyway, I say thank you very much, and I'm willing to help you as much as I can, but you guys can't forget us.
oh,
Okay?
well,
Thank you.
well,
Awesome.
This belongs